Olá, amigos do Brasil. Olá, amigos de Colombia. Good evening, everyone. I'm João Rafael, and I am the YIN representative of Brazil, together with my friend Eduardo Muniz. We are very glad to be here today, this night, with this joint event with Colombia, YIN Colombia, and I have as my co-chair Juan Pablo Robledo, and I would like to say just a few words before we talk about very interesting topics regarding international tax aspects. This is actually the second joint event we're doing. We're promoting here from the Brazilian side. We did the first one with Mexico a few months ago, and it was a tremendous success. And I hope this event will be even better. And of course, we have our intention is to make other events, also joint events with South American countries. And of course, we want to make this not only a single event, but the first of a round of events we want to continually be promoting here. So just before I start, I think we have a lot in common in Brazil and Colombia. We're both Latin American countries. We are colonized by Iberian countries, and we are relatively recent democracies, but we have very steady and democracies that during the last 30 years, we have succeeded in very special achievements in the economic and social areas. So today is an opportunity for us together to discuss tax topics. And I say that besides this sharing common interests in tax matters, we have also common interests in some of our main passions from our countries. We all love drinking coffee, and both Brazil and Colombia are major coffee producers in the world. And also we have a very common passion, that is soccer. And I can tell you that in the 2014 World Cup, I was in the Maracanã for the match of Colombia and Uruguay, when James Rodriguez scored that magnificent goal, which was considered the most beautiful goal of the World Cup. And I can tell you, all the Brazilian crowds there, we were rooting for Colombia. And we were yelling and shouting and celebrating that victory. In part, of course, due to our appreciation to the country, Colombians, and also because you were eliminating Uruguay. That was our rival in the 1950 World Cup. The World Cup Brazil had hosted before, and they won the World Cup right here in your country. So you did justice, sort of 50 years later for us. So we always like to root for Colombians, especially, that in matters of organizing World Cups, Brazil is not definitely a good example in the success. You know what happened in 2014. But when we organize tax events, then I think we have something very good to be proud of, right? In the 2017 IFA Congress held in Rio here, we had a marvelous experience receiving all of you, of course, our Colombian friends too. And I think today, it's part of that we are doing. You're not talking about soccer, we're talking about tax matters. So we're all on the same side here, to talk about interesting topics in this joint event. So I'd like just to, before we start, to say that we are very proud that this is not only a YIN event, but also a WIN event. As you've noticed, the majority of our participants are women, very talented tax experts. And I would like to start this event with a few words from our YIN representative, Center YIN representative, Claudia Sutter, who is joining us right now from Switzerland. And she is not only a YIN member, but also a WIN member, and of course, a very talented and helpful leader of our YIN, because it's almost midnight in Switzerland, and she is here to join our event and to say just a few words. Claudia, please, if you may.
Thank you very much, João, for your really nice words. And it's indeed my pleasure to be participating at this event. I think it's I've told it at the introduction we had internally. I really appreciate these events because they bring together YIN across the borders. That's what we stand for as YIN Global. And this is what we want to encourage, to have a network not only in your countries, but across the borders, because we are a network of international tax advisors, and that's where we can and make help each other out, contribute to each other's success and forthcoming. And it's a great honor and a great pleasure to be part of this, and to witness that you actually live the core of YIN, namely that you live the network of young international tax specialists. We've at YIN Global, we try to organize, or we've tried in the past to organize a 1 year get together at the IFA Congress. Not on the one hand, we had the YIN seminar, but most importantly, we had the YIN party, where we could gather and party and enjoy our lives together, which we are a little bit deprived of since last year, and also we will be deprived of this year. And therefore, it's even more important that we use the means that we have, and that we started collaborating by way of other means in terms of organizing these Zoom events among young IFA branches internationally, and not only within one country. So I think you live what we've already started appreciating last year, that we can collaborate across the borders, that we don't need to have these annual meetings, and that we may do that on a more recurring basis. So I'm very much looking forward to your future events that you'll also be organizing, and I'll be happy to contribute or to listen in at least there as well. There are other branches who do similar events, and so please tune in on the IFA website to find out the latest event calendar to see what's going on. And definitely we'll be organizing a quarterly meeting going forward globally, in order to activate also the international network globally. Therefore, we look forward to your contributions also when it comes to events that we will be organizing this year at a YIN global level. But I think it starts from a smaller scale, and from that scale where you have so perfectly organized so far. And I will now remain silent and listen to the interesting speeches and panelists that will come. All the best of success.
All right. Thank you, Claudia. I would just like to say a very brief words here to thank you very much, Claudia, and all the IFA and YIN support for our initiatives. We had the first event with the Mexican branch. It was a very nice event, and today we have this event with the Colombia IFA, and this is a very special event also because Brazil is at this time trying to join the OECD, and these mean changes in the tax legislation, change in the transfer pricing legislation, and also at the international level, the international tax law is changing. So it's very nice for us to have the opportunity to change here experiences and discuss the interactions between Brazil and Colombia. I would also like to thank a lot for our local branch, ABDF, for the support, the Colombia IFA branch, here represented by all the panelists, and especially Juan, who's the chair of YIN in Colombia, and also the work of Francisco Lisboa, who had a problem and could not join us this time, and also João Rafael, who is also the chair of YIN Brasil. Thank you all very much, and thank for all the panelists here, Ana, Bruna, and Gabriel, also friends of us, and wish you all a very nice event.
Juan, I think I can introduce you, and then you start presenting the first panel and saying a few words. But just to say that Juan, besides being the YIN chair at Colombia, he is also a member of the Colombian Tax Authority from the legal department of the Central Colombian Tax Authority. And it's a pleasure to have you here, Juan, with us. And please, if you could say a few words, please.
Thank you, João, and thank you, Eduardo. Well, I would like to thank all of you for participating in this great initiative between Colombia and Brazil, which I think could be the beginning of an interesting space for our countries, or maybe other countries of the South American region, to discuss experiences and challenges of international taxation. I have to say that I'm very glad to inform, as João said, that today 5 of our speakers are absolutely brilliant and amazing women. So this is beautiful. I think this is a great day for us. Also, I would like to highlight that Colombia and Brazil are willing to sign a double taxation agreement. Therefore, this event is a great opportunity for all of us to start understanding the system of both countries. In this regards, now I have the pleasure to introduce our first panel, which will be about the experience of Colombia joining the OECD and the challenges for Brazil to become a member. This panel will be presented by Natalia Quiñones from Colombia, who is the international tax partner of Quiñones Cruz in Bogotá, Colombia. Until January 2020, she was the head of the Office for International Affairs at the Colombian Tax Administration. She is a PhD candidate in the tax law at Amsterdam University, a JD from the Universidad del Rosario, philosopher summa cum laude from Universidad Los Andes, specialist in tax law from Universidad del Rosario, and LL.M. in New York University. Currently, she's a member of the executive board at the Colombian IFA branch and was the chair of the branch until July the 1st, 2020. She teaches international taxation at the Universidad Los Andes in Bogotá and is a guest lecturer in various settings around the world. Also, in this panel, Ana Carolina Monguilod from Brazil will be talking about this matter. She's an LL.M. at the University of Leiden, and she is the current director of Brazilian IFA branch and co-chair of the IFA YIN Brasil. Also, she's a professor at the Innsbruck and coordinator of the group of studies on tax policies from Getulio Vargas Foundation. Ladies, you have the panel. Please continue.
Well, thank you so much, Juan. I'm absolutely delighted to be here, and delighted to be here because I'm feeling young again. So it's great to be here. And thank you. I thank you very much for your invitation. Thank you, Eduardo. Thank you, João Rafael. Thank you, Francisco Lisboa. And thank you all the panelists that will share this great event with me today. Well, we will be talking now about, I will be talking now about the possible accession of Brazil to the OECD. And I thought I planned a brief talk about how it takes place. Maybe, I know that you guys in Colombia, you are used to it, but maybe people from Brazil, they are not used to deal with the accession process. And just to put everyone on the same page, the process begins with the formalization of the accession request. And then the request has to be analyzed by all the OECD member countries and accepted in a unanimous manner. And from then on, we would enter the accession roadmap. And this accession roadmap will establish, will will help us to work out the negotiations we'll have to carry out in order to become OECD members, and we will have details about the terms and conditions and in general the process to be followed by the candidate. And going to the next slide. And in order to become an OECD member, we would have to meet a few fundamental principles. And we will have these requirements we have here in this slide. The candidate would have to have, and I think that this is the most important issue here, would have to have a like-mindedness with the other OECD members. So this candidate should follow a market economy and democratic principles. And then in this and in the next slide, we would have a few requirements for the candidate to meet in order to become a member. So we could go to the next slide, Juan. And in here, we have a few requirements that were established in 2017. In 2017, the OECD developed a document establishing exactly the framework for the consideration of prospective members. And we have a few additional requirements which we hope Brazil will meet in order to become a member. But going forward to the next slide, Juan. The fact of the matter is that we are still a candidate. Brazil has presented its official accession request to the OECD in 2017. And in fact, 2017 was a very special year because we had the IFA convention, annual convention here in Brazil in that year. And I remember that it was very interesting to hear the OECD members. Pascal came to Brazil and he spoke a bit about it, about how, what it would take for Brazil to become an effective member. We do have other countries also waiting, also trying to become members, like Argentina, Peru, Romania, Bulgaria, and Croatia. They also have expressed their formal interest in joining the OECD, as Brazil has. But we have not yet started our roadmap, our accession roadmap. And I would love to hear from Natalia afterwards. How was it? How hard was that roadmap, that accession roadmap? And we do know that is a long, long road to be followed. So usually the accession process takes many, many years. At least I've heard like things like 5 years. And if I'm not mistaken, I think that Colombia took it like 7 years to become a member. And going to the next slide. So what Brazil is doing to get there? So we are a potential candidate. We still do not have a accession roadmap. And the Brazilian government has already executed, it seems, more than 90 of the 245 legal instruments that would be required by the OECD. So we are still a long way from the 245 legal requirements, but we do have another 50 instruments under analysis. So we still have a long road ahead of us. And Brazil has, as we all know, Brazil currently participates as a member in the OECD bodies, projects, and activities. And in the field of taxation, we do know that the OECD has been working closely with the Brazilian tax authorities in the field of taxation, of transfer pricing, and we do have a panel on that afterwards. And I think that that's, from a tax standpoint, that's the most important thing for us in terms of alignment of convergence of our rules to the OECD standards. So going to the next slide, Juan. So what would be our real chances of getting there? Well, it seems that we are trying to get there, and probably if we take into account the other potential candidates, Brazil has been doing its job, and it seems that the closest, I wouldn't call Argentina a competitor, but it's like the closest other country trying to become a member is Argentina, which has around 50 legal instruments met so far, while Brazil, as I said before, has already executed about more than 90 legal instruments, of those instruments required by the OECD. And until a while ago, we heard on the news that Brazil probably was behind Argentina on the OECD's intentions of making a new member. It seems that until last year, the Brazilian government was keeping a good relationship, especially with the United States, and our chances of getting to the membership, they increased. But now we have a new administration in the US, so we might be facing a new scenario. We still don't know. And we have to keep in mind that the becoming a candidate and becoming a member and the accession roadmap, of course, we do have many legal and technical issues to meet in order to be accepted, but there is also a political side of it. So from a political standpoint, the other OECD members would have to, in fact, accept us. And going to the next slide. Oh, in here, I just had a few pages of a very interesting report from the OECD summarizing the work they are doing on taxation. And going to the next slide, Juan. We have in this page of that report a list of the core principles around which the Committee on Fiscal Affairs of the OECD, around which they work. And we do have some work to be done. And I think that, of course, Brazil has very peculiar tax laws in several aspects. But I think that the most important aspect is the one which we will review in a while in the second panel. It's like, I think that the one thing that from the tax perspective that could keep us out of the OECD, and I've heard it from someone from the OECD that would be a deal breaker, and we know that would be a deal breaker is our transfer pricing rules, and they do have to be aligned in order for us to join this organization. And I think that based on what we have been following from the work that the Brazilian tax authorities and the OECD have been developing together, we see that the Brazilian tax authorities, they are actually willing to make this alignment. So that's the hopeful side of it. And the only problem is that this would, of course, involve the passing of new laws based on which our current transfer pricing standard would have to be drastically changed in order to embrace the OECD standard. And then we would have to depend upon our Congress. And that is a very big political issue. So hopefully we will have great success, and I think that we are having great success on the efforts that the Brazilian IRS, the Brazilian tax authorities, are developing with the OECD on such alignment, the possible alignment. But after this is done, we will need a law being passed by our Congress in order to actually implement it. And going to my very, very last slide. So why Brazil should or should not become a member? We have been hearing a lot in the last few years, if from a tax standpoint, it would be interesting or not to Brazil to become a member, especially because the Brazilian tax laws, they are somewhat peculiar. Everyone here knows Kees van Gaard from the Leiden University, and usually Van Gaard, he used to joke that in Brazil we have funny tax laws. We have very interesting and funny tax laws, and they are interesting. And due to that, I think that some people they have doubts about our interest on joining or not the OECD from a tax standpoint. And in my view, I think that never in our history, never before, it was so important for us in Brazil to join the OECD. I think that it would be a great step forward for Brazil. I think that by joining the OECD, Brazil will be above all committing itself to very important and good public policy standards. And besides the tax stuff, we have much more behind it. It's like Brazil will be committing to follow good governance. Brazil will be committing to keep our environment safe. Brazil will be committing to fight corruption. So I think that this is a fantastic step, and I'm really looking forward to seeing Brazil as a member of the OECD. And I'm always also very anxious to hear from Natalia, how was the Colombian experience when Colombia went through that. Thank you, guys.
Thank you, Anna, for the very interesting debate that you posed. I really like your last question, because I've changed my mind. You know, I used to say that I was very opposed to Brazil joining the OECD from a tax perspective, because I did appreciate the simplicity of the rules and the low the low litigation arising from your transfer pricing rules. But now I've changed my mind and I agree with you. I think that it's a good time for Brazil to start this process. And I'm really looking forward to more diversity inside the OECD. I think that if we bring on more countries like ours, like Colombia and like Brazil, we will definitely be able to give some shape to the rules that will make them administrable in our regions. So get rushing, because now I do agree with you that it is important for Brazil to join. Speaking of the Colombian process, if we go to the next slide, as you said, Anna, it took us 7 years. We started September 2013, and the official accession date was April 28, 2020, only last year, after a very, very extensive discussion with the 23 committees that review the standards. We got an actual invitation on May 2018, but I must say that the longest delay had nothing to do with taxes. It had more to do with unions and a discussion on what we did with waste material. So nothing to do with taxes. If we go to the next slide. we will see here the 8 principles that you showed us, Anna, in the What We Work document that they released. So after all the discussions from 2013 to 2018, the recommendations are the same as those written in that document, and I think they might be the same for you. They're very, very general. You have to use the OECD model to relieve double taxation. You have to deliver data and information. I think here's the most contentious one for Brazil. You have to acknowledge the primacy or superiority of the arm's length standard and apply. I think here's the difficult part, because I do believe that your rules comply with the arm's length definition in a general sense. But the difficult part is applying the OECD transfer pricing guidelines, which is also a part of the recommendation. So from your rules to the OECD transfer pricing guidelines, there's a very long way. I think the Receita is doing a great job in asking taxpayers out there what they think. I think the consultation process is over now, but I really appreciate that they heard the voices of taxpayers in how to keep things simple, because I think that's what Brazil stands to lose the most if they choose to apply the OECD guidelines. They lose simplicity and tax certainty. So, so with the consultation and with the convergence document that they issued jointly with the OECD, we have a bit more of an idea of how the convergence could be achieved and how Brazil could very promptly join the club at the OECD. The rest of the objectives have already been spoken by Anna, so we can move on to the next slide. The minimum standards, I think, are already complied with by Brazil. It is definitely mandatory for any new OECD member to comply with these, but it's also mandatory for every inclusive framework member to comply with these. And because Brazil is a member of the inclusive framework, you are already compliant with all these standards. And I have to say, in my experience, Brazil is actually a very important leader in some of these discussions. So not only are you compliant, but also you bring very important points to the discussion at the OECD regarding how to measure and how to evaluate compliance with these 4 standards, which is not easy given the difficulties in our region. For example, Colombia has no experience with MAP. How can you evaluate compliance if there's no cases that have been resolved? So what they do is they look at the legal framework. So I think, you know, all those contributions by Brazil will continue to be very valuable, although you're already there for the minimum standards. If we can move to the next slide. I think here we have some of the things that will bring being an actual official member as future implications in the tax arena specifically. Like Ana Carolina said, the most difficult concern there is that the agreements that you sign need domestic laws, and you need to go through your Congress for that. And that is one of the biggest reasons for the delay in Colombia's accession. We were very slow in Congress to approve this. We had many leftist representatives that did not feel like the OECD was helpful. We did face very harsh reduction in the international aid from international organizations and multilateral entities. And, you know, we are a country that really needs international aid, especially with the Venezuelan refugee crisis and transitioning to peace. And this was a negative consequence that was announced in the Congress discussions. You might probably face a similar discussion, whether you're willing to lose some of the aid, because becoming an OECD member means that now you're funding other countries that need help. So that's a very important transition in the development of any nation. There's also the timing and competitiveness component there, which is very, very tricky. especially with the new discussions with the digital economy. If we do approve of a minimum global tax, which is pillar 2, which is the most likely to be approved in these discussions, if you're very fast to introduce that tax, you may lose competitiveness as compared to other countries in the region. And that might be another element that your Congress might consider when delaying the approval of some of these instruments. Then there's also some upsides to being a member officially. You get the coordination of exchange of information and JITSIC. Brazil is already piloting JITSIC, which is the international task force for the secret intelligence of tax administrations, where they share information about recent cases that they've been dealing with. So they sit together, the developed country tax administrations with developing country tax administrations, and they exchange, notes on their cases. It's really a very productive platform for the Receita, I think. There's collaboration in tax crime as well. And hopefully there will be more collaboration in dispute resolution. This is something that we always lack in our countries, where arbitration is not yet readily available for any tax dispute, and litigation may take very long. So hopefully some enhanced mechanisms will be available if pillar 1 or pillar 2 goes forward. We also have capacity building, which is nice for the tax authorities, and bilateral programs with other OECD countries, where they can teach how to use artificial intelligence, for example, which is very novel. Colombia partnered with the Norwegians, for example, in the use of big data. So this is something that I think might be positive for the tax administration. And then there's the question of sovereignty. Once you become an OECD member, they do expect some alignment with the majority of the members. And this is why I feel like it is very urgent that Brazil joins, so that we start forming a new majority where we can be aligned in policy objectives that are doable for our region. Next slide. Here are some general trends for Colombia after joining the OECD. We have new DIAN staff. DIAN is the equivalent to a Receita in Colombia. Some of the new staff is Juan Pablo here present. And what this has achieved is an increasing flow between private practice and DIAN career staff, which I think is very, very positive, as members from private practice bring an understanding of the business that sometimes is very hard to get if you have not been in contact with what taxpayers are doing. You also get increased capacity, increased investment in training and technology specifically. And then you finally have fully bilingual staff in the key international positions, which I think is also very positive after Colombia joined. We increased our participation in the inclusive framework. Colombia was appointed to the steering group in 2019. Brazil, I must say, is already a member of the steering group, so you are already a very important voice in the discussion. But there may be other areas where the Brazilian voices can become more important once they are officially a member. Colombia has also officially voiced their support of multilateralism. So, I think we are all waiting for July and seeing if there will be some agreement on how to tax the economy of the future. And I think even Brazil has expressed a desire to wait before they introduce some unilateral measures on digital. We've, for now, emphasized audit on VAT and the digital, which is already a consensus in the OECD, and which should be interesting for Brazil if you finally achieve that reform objective of eliminating PIS and COFINS and all of that, and getting an actual VAT in place. But this also reminds me of a challenge that I would like to hear from Anna at some point later in the discussion, on how the subnational levels, you know, the states and the municipalities will be participating in this very big transformation. In Colombia, it was more easy. It was easier because the municipalities have limited taxing powers, but in Brazil, it's much more complicated. So I'd love to hear from you guys on what perspective you see on that. And then there's a hopeful note. I think we are heading towards a more common policy for Latin America. I think we're starting to focus on commonalities and not just on the differences, which had been the focus in the recent years. So we are definitely seeing an increasing trend for cooperation in the G24. For example, the G7 is very active, the UN is also very active, the Argentinians are very active. So I think, you know, there might be, hope for having bloc positions inside the inclusive framework, and hopefully the OECD as such. I think that's it, so that we can have some discussion or some questions. Juan, can you move? Yes, that's it.
Well, Natalia and Anna, thank you very much for your amazing presentation. It was really delightful. Well, I want to say to Anna if she wants to say something about Natalia's question about the municipalities' difficulty in becoming Brazil a member of the OECD.
I would say, Juan, Natalia, great question, but we would have to spend like the next hour talking about it, because there is nothing more complex than tax reform in Brazil right now. But you are right. That's a big issue, because our cities, our municipalities, they do have a great tax authority in Brazil in power. And it's very complicated to implement any of the tax reform projects we currently have. And I'm also delighted to see how you, Natalia, know Brazil. You know a lot about Brazilian taxation. Congratulations. I loved your presentation.
Thank you. Well,
open to the floor or the other panelists.
So thank you very much for your presentation, Ana Carolina and Natalia. As I mentioned, it was really nice to have you and hear you. And now João is going to continue presenting the second panel that we have for this night or afternoon, depending on where you are located, especially Claudia, that she's in Switzerland right now. So please, João.
She's not in a tax haven. She's in a tax rave, right? Because of electronic music with tax. Okay. But anyway, just a final remark on your comment. I think the presentations were excellent, and I have to congratulate you guys in Colombia. You did such a beautiful job and admitted you. I think the third Latin American country being admitted in OECD. I think some of us, we probably hear what you heard in Colombia, that OECD is just a rich countries club. So why Brazil has so interested in joining it? But I agree with Ana Claudia. I think it's more than that. It's a seal and a stamp of we were following free market rules, and you really and strongly believe in democratic principles. And that I think that's the basic for having a fair taxation. So of course, Brazil would benefit a lot from joining the OECD. And I think perhaps this can push our tax reform, because it's so hard. I mean, we have tried so many things. Why not something from abroad? Yeah, and doing and listening to some of what are the good guidelines that other countries have made, and adopt them and somehow manage to do our tax reform. Perhaps that's the push we were needing. But I think one of the basic and most intriguing questions, as Natalia and also Anna have told us, for us to join the OECD is, of course, when it comes to transfer pricing rules. So to discuss this specific topic, we have here two very talented tax experts. Bruna Ferrari from Brazil. She's Master of Laws from Fundação Getúlio Vargas in São Paulo, and the legal tax manager at Klabin, SA. And Laura Sanint, I'm afraid I'm not pronouncing your name right.
Yes, no, that's correct.
Right? Oh, yeah. Great. Thank you, Laura. So she is lecturer of the tax department at Universidad de Colombia, and she's partner of Sanint Rivas. And ladies, please go ahead. The panel is yours.
Thank you. Thank you, IFA, and thank you everyone joining us today. And Bruna, it was really interesting to elaborate this panel with her. So we want to start with maybe if you can, Juan Pablo, the next slide, please. Thank you. So we want to start with the overview of Colombia experience, joining the OECD, but in transfer pricing matters. And as I told Bruna, even if Colombia became an OECD member until last year, from the beginning of the transfer pricing regime history here in Colombia, almost 20 years ago, Colombia included in the tax code the OECD guidelines as a tool of interpretation for purposes of the law. Actually, that was a little bit crazy, and the Constitutional Court declared the article unconstitutional since we weren't even a member of the OECD. But the court admitted the OECD guidelines as a valuable interpretative tool. So it's undeniable the influence of the OECD guidelines, because the OECD guidelines and the OECD has always been strong in Colombian transfer pricing regime, and Colombian regulation follows very close what the OECD provides, what the OECD suggests, even sometimes replicating parts of the OECD guidelines or replicating articles of the OECD model. For example, when defining the arm's length principle, the tax code basically replicates Article 9. So that happened from the beginning of the regime here in Colombia, and especially since Colombia initiated the process of becoming an OECD member. So I would dare to say that there haven't been really a before and after convergence into OECD guidelines in Colombian transfer pricing matters, at least. It's almost like if from the beginning we were already there. After becoming a member, Colombia's position on the enforceability of OECD guidelines remains the same. From a formal position, neither the OECD nor Colombia have made any pronunciation about it. And from a legal standpoint, Colombian legislation didn't establish any obligation for Colombia to apply directly or even via interpretation the OECD guidelines. But as I told you guys before, we follow really close the OECD and the OECD guidelines on transfer pricing matters. So that's a little bit the overview of Colombian experience in transfer pricing regime from where we started until now. That is really similar in the way we follow the OECD and the OECD guidelines.
Thank you, Laura, and thank you everybody thank you ABDF and IFA, Eduardo, Francisco, João for the invitation. And I would also like to congratulate all the panelists. So just to explain a bit, because we're going to go through the whole presentation like this, we are always going to compare Colombia and Brazil. So it's like a debate comparing both our legislations and the differences that we already have. So, and I would also like to thank Laura. We discussed a lot about how we would do the panel so that we could be restrained to our time limit, but also bring the main points regarding the discussion about transfer pricing. So just to compare, as Laura mentioned, for Colombia was already adopting OECD arm's length approach. And in case of Brazil, it's totally different. As we know, we do have significant divergences from OECD system. So just to have a broad overview, we do have fixed margins and traditional methods. We do not have transactional methods and other methods. So this is the main concern of OECD when we analyze and discuss about possibility of double taxation and double non-taxation, because our legislation works pretty much differently from all over the world. So it's totally different. And it's also very different from Colombia. So that's why we are really concerned about how we're going to do this convergence and how we are going to adapt our legislation to the arm's length approach. We also do have a freedom in the selection of methods. So the Brazilian taxpayers do not actually need to adopt the best method or the best one which would be applicable to certain transactions. Having more than one, it can be chosen. The taxpayers could choose, for instance, the one that gives the minimum taxation or rely on any other possibility of choosing the method. So there is not a mandatory application of one method specifically, apart from commodities. So this is also a difference which is pretty much highlighted towards the whole study that that OECD and our federal revenue have been performing throughout the last years. We also only have general rules applicable to services, goods, and rights. So we do not have specific provisions for cost contribution arrangements, for reorganizations, for specific type of services, for low value services. So it's pretty much a straightforward method and margin for any of these operations, be in services, goods, or rights. And this also brings a lot of questionings regarding double taxation and double non-taxation, in which is the main purpose of Brazilian legislation, which actually today would be more to guarantee a minimum revenue than seeking both of these aims of which are the principal aims of the transfer pricing guidelines. And also going for financial transactions, we do also only have a very broad legislation. So we do not treat specifically cash pooling. We do not treat specifically derivatives, hybrid transactions, etc. So just to give a highlight, we are always talking about a more broad legislation and already fixed and determined methods. And we do not have advanced pricing agreements. So it's kind of more simple and more straightforward, but also it brings a lot of complexities regarding all of this communication, let's say it like that, when we do have international operations with other countries that do apply the arm's length principle. So maybe we can go to the other slide. And then considering the whole background that I have already spoken about, what are our main concerns? So primarily, we always say that Brazilian transfer pricing legislation is very simple and straightforward. So we would be changing simplicity for the arm's length subjectiveness. And in this matter, there are a lot of questions on whether this would actually be better for Brazilian taxpayers and Brazilian tax authorities, because for once we would already lose in the primarily the ease of compliance and ease of tax authorities ease of tax administration. So in the beginning, this would change a lot. Our tax authorities also do not have experience with comparables database, benchmarkings, and also doing all of this analysis and economic research, etc., for transfer pricing studies. So there is a lot of uncertainty on how we would be applying the arm's length method, the arm's length principle, and all of the OECD methods and margins, which are very subjective to each taxpayer in Brazil. We also would like to we have a concern on if whether the applying OECD arm's length approach, we would actually prevent double taxation and double non-taxation in practice. Because one of our concerns is the timing. So how long would it take, for instance, for tax authorities to analyze and validate an APA for us to, how it would be to apply the safe harbors that, for instance, OECD is trying to somehow convert our fixed margins into, and how would this lead to an increase of tax assessments? And one of the discussions, or the main point that we discussed, me and Laura, is how it is happening today in Colombia.
So in Colombia, as I told Bruna, Colombian taxpayers have the right to request rulings from the tax authority, even in transfer pricing. I think in Brazil, you don't have that faculty. Those rulings can't address particular matters. They only can refer to general and abstract situations, and those rulings are not binding for the taxpayers, but only for the tax authority. But since they are binding for the tax authority, usually taxpayers do base their actions on those rulings. On legal certainty in Colombia, it's quite difficult to find. I think you must know that we have records on the number of tax bills in the past years. Regarding a specific transfer pricing transaction, is not as we have a broad regulation on each transaction. For example, as Bruna told us for Brazil, in financial transaction here in Colombia, there are some general mentions, but there is no specific guidance on guarantee fees or cash pooling, or the same as with services. We have some general mention, but in some requirements, but nothing too specific. Regarding the tax authority challenging transfer pricing matters and judges, I think Colombian tax authority used to take a really formalistic approach when challenging, and it used to challenge only like delays on the filing or if the taxpayer concluded in its own transfer pricing study that its transaction fell outside the range, and then he didn't amend the income tax return, making it to the median of the range. That's the way it is provided in Colombian law. And then when the substantial challenging began, I think there was some discontent on the taxpayer on the level of knowledge of the tax authority on a matter so complex, and which with the penalties being so high, because here in Colombia transfer pricing penalties are really high. I think now that level of knowledge has improved, not only in the tax authority but also in courts. But since in Colombia the processes in general take so long, as I think Natalia was the one who mentioned it previously, currently they are still deciding on matters that doesn't really deserve the cost, including the cost of time of either the taxpayer, the tax authority, the judges, and also slows the process of getting to real cases for the country. That is just a few like general matters on that matter. I think Juan Pablo, if you can pass to the next slide. So regarding and that's it, like the importance of the difference between the practice and the theory, because we do have some rules and some law, but from that to being what the law specifies the reality, we are really far away. So for example, a corresponding adjustment may be made by a Colombian taxpayer, we have that in the law, whenever it is provided under the applicable tax treaty or whenever the tax authority accept that corresponding adjustment. But I haven't seen one, and I'm quite sure that there hasn't been one either. And so that what we were discussing with Bruna is that, for example, and I think Bruna is going to talk about it now, and that is, I mean, we have the corresponding adjustment, but we haven't done one until now. So one is the thing that is written in the law, and another thing is the things that actually happen in practice.
Yeah, regarding secondary adjustments, as already mentioned by and Laura was talking about it, we do not have secondary adjustments in Brazil. However, one main point here that we need to consider is that even though we do not have secondary adjustments, our current CFC rule mostly already adjusts all the transfer pricing and profit shifting that we do have in international transactions. So this is a good point, which sometimes is not considered. So of course, we do have a problem when we are talking about double taxation, because we do not accept mostly the adjustment of the what should have been taxed in the other country, but in the opposite sense, when it has not been taxed in Brazil and the profit has been shifted to another country, which would be mostly the purpose of the secondary adjustment, normally we already cover it with our CFC rules. So it's difficult for a company to not include the profits and tax it in Brazil. So this would be a point that if we do have secondary adjustments, how we would adapt our CFC rules. So this is a big questioning regarding the conversion of our legislation into OECD arm's length approach and how we would then deal with CFC rules. So I think this is one main point that we do have here. The second part is, as I have already mentioned, we do not have a lot of experience with comparables, with benchmarking analysis, and so on. The only experience, or the biggest experience we do have, is with the CUP method here in Brazil, and also mostly with the mandatory rules applicable for commodities, because we always need to do an analysis of the public exchange. So, and we need to do an averaging of the published commodity price from public exchange on the transaction date. We need to analyze everything, and this is the price mandatorily that needs to be applicable. So I think this is our biggest experience with the part of comparables. And one main concern that we also have here when we consider this possible convergence is how will the tax authorities analyze and question these adjustments, question what actually we are utilizing as a transfer pricing method and margin. So as Laura was saying, Colombia has a lot of tax assessments. Nowadays, our tax assessments have been reduced a lot. We had a lot of tax assessments discussing one of our mandatory, not mandatory, but one of our optional traditional methods, but nowadays it has been reduced a lot. So This, I think, is the biggest point here when we think about practice versus theory. I think we can go to the next slide. And then when we go to APAs, this was very interesting because we are discussing a lot the public consultation that the Federal Revenue and the OECD recently released, and now it has already been closed, discussed a lot about safe harbors and APAs. And one of the approach suggested by OECD was that we might have an APA per sector or per business activity. And for us, it was, although it might help, of course, there are some good points and some points that we need to consider a bit more. We thought about it being a hybrid approach, because how would taxpayers in their specific sectors open all the economic information and the substantial and particular sensitive information of the business to other taxpayers and to the tax authorities. So this is one of our main concerns about this proposal that we currently have. And I think OECD and the Federal Revenue are still analyzing so that we could have possibly a final position. And the other point is, would we be able to opt out if we have a sector APA? How would it work in practice? Because it would not be an individual APA, it would be applicable per sector. It might be that my company is actually not with the margins which were, or doesn't have all the economic similar information of the other companies which were being considered, being it because it is a medium company or a bigger company, etc. So it is also a concern when considering the applicability of APAs in Brazil. And the other point is, of course, as I already mentioned, we do not have a lot of experience. So if Laura could explain a bit how it has been going in Colombia.
Well, we haven't got so much much away than you guys. In Colombia, there is currently just one APA. It was signed a long time ago, 7 or 8 years ago. We don't have any public information about it. So I just can say that we have one. For APAs, and going back to the legal certainty, for APAs, the requested information is really extensive and contains, in addition to a lot of other information, an explanation of the economic or legal reason why the taxpayer wants to enter into an APA. I mentioned this because I found this requirement very complex to comply with. According to the law, the documentation that the documentation that the taxpayer presents and the information that the taxpayer gives for the APA will only have effects in relation to the APA process and will be exclusively used with respect to it. But there are some exceptions. When the APA is revoked or canceled due to non-compliance of the APA, or when the information and documentation provided starting the process constitute one of the events of suspicion of tax abuse. And I find that really interesting because the law doesn't provide that the tax abuse have to be proven, but whenever there is just one suspicion of it, then actually we don't know what happens with the information because there is no known experience on what happens when that case arrives. So I think few of the main reasons of only having one APA are maybe time consuming, the complexity, the absence of legal certainty in many aspects related to the process before, during, and after the APA, and that led us to the next slide, please, Juan Pablo. and that is regarding safe harbors. There are no safe harbors in Colombia, and there are no safe harbors provided in the Colombian transfer pricing regime. I think maybe going into the OECD guidelines, low value adding intragroup services markup of 5% of the relevant cost that doesn't need to be justified by a benchmark study is pretty similar to a safe harbor, but there is no explicit rule in Colombian regulation about it. So I can't really say that there is a safe harbor in Colombia, even if that one provided by the OECD guidelines might be a safe harbor. I'm thinking, and I was discussing this with Bruna, and it was really interesting that what you guys have in Brazil, or what you want to have, is maybe something regarding the APA by sector that Bruna mentioned, is maybe something between an APA and a safe harbor. In a similar way, I understand APAs of maquiladoras work in Mexico. I don't know, but we thought that this was something worthy to mention. And also we do have the freedom of choosing the method that we want, except for the mandatory use of COP in commodities transactions and some other suggestions that the law makes, but we follow very closely the OECD on this matter too. So yes, we only have one APA, and we don't have safe harbors. And then we think that maybe what Brazil wants to do is something between an APA and a safe harbor for those APAs sectors in the industry, in each industry that Bruna was talking about. And that led us to the next slide. And Bruna,
Laura, just to mention about the safe harbors and what we currently have as a proposition for the convergence is that actually today in Brazil we do have safe harbors, but only for exportation. We have profitability tests, a 90% test over market price, etc., but only for exportation. So one of the main points which have been raised in the study regarding towards convergence from our current transfer pricing legislation into OECD arm's length was this point. And also another point is that what currently, or what we understand as the current proposal of OECD would be to have carefully designed safe harbor rules. So we would have safe harbor for a specific transaction and group of taxpayers as well. So it would be a kind of both the APA and the safe harbor would be kind of hybrid, because normally safe harbors would be applicable to less complex situations, but we really don't know here whether it would only be applicable to less complex situations or situations which are most commonly performed into the same group or sector of companies. So it might be that we do have safe harbors, for instance, for financial transactions. There are several financial transactions which are very comparable. So could it be the case, for instance, this is one question. The other one is, would it be for routine operations? And another point is that OECD, when it talks about the proposal of converting part of our legislation into safe harbors, it mentions that possibly it will be a way of transforming the fixed margins that we have nowadays into kind of this hybrid safe harbor. So this is something which we are currently exploring with OECD, but of course it's a different approach from what you already have. Actually, you don't have in Colombia, but just to mention. So we can go to the next slide, sorry.
So then we thought maybe it was interesting to talk about the country by country report in Colombia and in Brazil, and also the use of the information given through that report. So in Colombia, we have the country by country report since 2016 regarding the use of the information. The Mutual Administrative Assistance Convention signed by Colombia in 2012 came into effect in 2016, and Colombia is also party of the Multilateral Competent Authority Agreement on the automatic exchange of country by country reports, and it has 60 bilateral relationships activated under that agreement. And in addition of that, on August 2017, the IRS and the DIAN signed a competent authority agreement to exchange CVC reports automatically. According to Colombian regulation, the tax authority will not even use the CVC report to make a transfer pricing determination. It could use it only to start an investigation or to support a current determination. And also we have in Colombian regulation others warranties of confidentiality, as there is a general rule in the tax code on reserve of the information, which provides that all the information regarding taxable basis or taxes is deemed to be confidential, and the tax authority may use it only for control, collection, determination, discussion, administration of taxes, or maybe to statistical purposes only. But I think confidentiality is not a minor concern in any country actually on this matter. Remember that in 2016, the French Constitutional Court declared the obligation to present the public report of the CVC as unconstitutional, considering that forcing the companies, the taxpayer, to disclose their business strategy through some public reports, allowing competitors to maybe identify key elements of their industrial and commercial strategy, would affect the freedom of the company in a way not proportional to the objective of the CVC report. I think that position is proof of the importance of the information included in the CVC report and why it is so important to keep it confidential. As CVC reports, and as I told already, at CVC reports can be exchanged automatically between tax administration, I think it is important to mention that although in 2015, Colombia peers review report of the Global Forum of Transparency and Exchange of Information for Tax Purposes, Colombia was found to be compliant with ensuring confidentiality in its legislation, and in practice, said report also brought the attention to the fact that Colombia was relatively new in exchange jurisdiction to exchange the information, and therefore no special systems like software or firewalls were in place for recording the details of the exchange request, neither a formal exchange of information unit or even a process was implemented by that year. I don't know if we already have an implemented process or unit to do so. I don't think so, at least not publicly. So I think it is still like really important to certify that the use of the information of the country by country report is safe for the taxpayers, because I think that's a major concern. But then also, before Bruna start talking, but then also, since we have like the thresholds of the OECD, that is that the CVC report applies to multinational groups with consolidated income equal or higher than $827 million, then also we don't have that many experience because we don't have that many companies here in Colombia that complies with that threshold. So.
Okay, just going to the next slide so that I conclude the panel, considering that we have already trespassed our time. So just a few questions here. Of course, it's more provocative questions so that we can think about it. One of the points we discussed is whether it would be reasonable to change now, considering digital economy advances and the world post-COVID-19 pandemic. So we saw that OECD already released some guidance on how to adjust transfer pricing issues concerning this pandemic time, and it wasn't suggested new methods or any other mechanism, just some ways of adjusting comparability issues and so on. But it might be something to consider mostly because of the advances of the digital economy. But even then, I think that formulaic approach guarantees a minimum revenue, but it's not the most accurate. I think this is the biggest remark on whether we could or should do the convergence into the arm's length approach and all of the points we have already addressed here. So thank you very much, everybody. Sorry that we utilized more time than we should.
Hi, Bruna. Laura will speak or has ended the...
Yes, I mean, I have something to say, but I don't know.
Can conclude, no problem, Laura.
We are short in time. So I was just, I think I'm not going to say that the OECD method is wrong, as I told Bruna, but I'm not going to say that it is the correct one either. I think not even the OECD can assure it at this point. And proof of that is what has happened with the analysis of the digital economy. If the OECD method was assured as the best, the adequate, the sufficient one, they wouldn't have started to analyze what to do with it in face of digital economy. 5 years have passed now without a solution being reached. So I don't think anyone can say for sure that the OECD method works and the Brazilian method doesn't, or the other way around. And I think having that clear will be the best way of approaching the conversation on this regard.
Thank you, Laura. Thank you, Bruna. Just a brief comment. I couldn't agree more with Bruna with her last statement on which we really should question whether the arm's length principle is still the way to go, especially in Brazil, in our legal system, which is a law-based system. And in what concerns to transfer pricing, you were talking about the determination of the calculation base of the income tax at the end of the day. And I really can't imagine how we can enact a law detailing all the requirements and the methods for calculation of a real arm's length method without causing further judicial litigation discussions on whether the law authorizes the interpretation that the tax authorities later get to calculate the arm's length price. So although it's good to adopt the gold standard and the OECD standard, it can become a little bit chaotic here in Brazil, particularly considering our tradition and our litigation with the tax administration.
Anyone has any further comments? No? So Juan, perhaps you could introduce the last panel and then...
Well, actually, yes, I would like to say that the presentation made by Bruna and Laura it was amazing. I think I never saw a comparison of this topic so precise, so accurate. So I think it was amazing to have this experience. I really want to thank you, Bruna and Laura, for this panel. And maybe because of the time, I have to continue with our third and final panel, which will be about the comparison of the indirect asset transfer regulations in Brazil and in Colombia. This topic was selected for this event because of it was included in the Colombian regulation 2 years ago. It's a very new topic or regulation in Colombia, and since we noticed that you have this regulations also in Brazil, and that you are trying to become a member of the OECD, and these regulations are part of this of the requirements that you have to fulfill to become a member. We thought this was a great topic to review and to understand the differences that we have in both countries. So for this panel, our speakers will be Laura Duran from Colombia, who has a JD from the Universidad de los Andes. She's a specialist in administrative law at the Universidad del Rosario and has an LL.M in international taxation at King's College in London. She has 8 years of experience in tax matters, both nationally and internationally, and focuses on consulting and tax planning matters. Prior joining Baker and McKenzie, Laura worked as an associate in Godoy's Abogados in Colombia. Also, I have the pleasure to present our unique male representative of the panel, who is Gabriel Bess Mati. Gabriel is a Master of Law candidate at the Universidad of Sao Paulo. He has an LL.M at Vienna University, and he's associate lawyer at Brigado Duque Estrada Abogados. Sorry, my Portuguese is not that good, so I hope I said well. So please, Gabriel and Laura, the panel is open for you.
Thank you, Juanpa, and thank you everybody for joining. It's a pleasure to be here and be discussing these interesting topics with you guys. And also I wanted to thank all the panelists, and I wanted to thank the organizers of the event, IFA Colombia, IFA Brasil, and YIN, and of course, WIN. And I wanted to thank my colleague Gabriel. We had a lot of fun doing this, so I hope you enjoy it. Can you pass the slide, please? So as Juan Pablo said, today we're gonna discuss indirect transfer regime in Colombia. As he said, this topic is quite new. Before 2018, we didn't have that regime. So basically, indirect transfers of assets in Colombia were not taxed in Colombia. It was an attractive way of planning, let's say it like that. But since law 1943 of 2018, this regime was included in Colombian law. We had some difficulty with that tax reform. It was declared unconstitutional. So the government and Congress have to pass another tax reform in 2010. In 2019 is law 2010. And basically it included the same regime as it was before with some twitches around. And in 2020, Decree 1103 was issued, I think it was in August, by the tax office. So that's basically the regulation that we have in place right now, and a few rulings from the tax office. But what I'm trying to point out here is that the regime is quite new, and we're barely trying to digest it, to understand it, and lots of discussions have come up. So I hope you like it. Can you pass the slide, please? So basically, the indirect transfer regime tries to, or the scope of it is trying to tax the indirect transfer of Colombian assets through the sale or transfer by any title of shares, participation, or rights of foreign entities. what is really important here, or I think it was really interesting, is that the Colombian regime is really broad. For example, in Mexico or in Ecuador, the indirect transfer applies for very specific stuff. For example, in movable property or companies. In the Colombian case, basically it addresses any type of asset being indirectly transferred. That includes intangibles, companies, immovable property, or any type of asset, including account receivables. So that's something to watch out for. And the other thing is that the regime also considers not just companies, but also other type of entities such as trusts, foundations, funds, et cetera, So it's pretty broad. So it's quite different from other regimes. So this slide basically summarizes really quickly how it works. Basically, what the tax regulations say, that those indirect transfers are subject to tax in Colombia, specifically income tax. And to assess the income tax liability in Colombia, basically you have to check out for the difference between the price agreed between the parties and the tax basis of the transfer assets. However, in Colombia, it's really interesting that the tax regulations state that the tax basis corresponds to the tax basis of the holder of the Colombian underlying assets. And the price is the fair market value of the Colombian assets. So basically, regardless of the fair market value of the sale or transfer abroad, or the tax basis of the shares being sold or transferred, technically for Colombian purposes, you have to check out the local, well, the fair market value of the price of the local, of the underlying asset in Colombia, and the tax basis of the underlying asset as well. And here, there's another interesting thing about the regime, is that the rates could change depending on the situation of the transfer. For example, capital gains are taxed at 10%. And if it's qualified as ordinary income, it's taxed at 31%. And this is for companies, not for individuals. Individuals is a progressive rate between 0% and 39%. And technically, whether it qualifies a capital gain or ordinary income, it depends on the holding period of the shares of the foreign entity that holds the underlying assets in Colombia. So we're not looking in this case the underlying asset, but the shares of the foreign entity that holds the underlying asset. So that's something to watch out as well. Technically, the seller, and this is exactly what the law says, the seller is obliged to register in Colombia and file an income tax return within the following month. But here we have had some difficult technically issues, because of specifically, it says the seller is obliged to register in Colombia and comply with formal obligations. Since the regime applies not just for sales, but also for other types of transfers, and this includes contribution of capital, reduction of capital, liquidations, donations, etc., any type of transfers. So technically, sometimes the entity subject the entity or individual subject to income tax in Colombia, it's not maybe the person transferring the assets, but the one receiving them, for example, in a donation. So we have had some issues there, because the law says the seller has to file the return, and technically it could be not the same person subject to income tax in Colombia. Also, another thing is that if the buyer qualifies as a withholding agent in Colombia, a withholding has to be done on the payment or accrual. That could lead, of course, that the seller can credit the withholding tax like its final income tax liability, but this could result in a balance in favor. So technically, the seller would not just be obliged to register in Colombia and file an income tax return. Possibly, if he has a balance in favor or not, it would have to go to the tax office and request the balance in favor. And of course, that's not easy peasy here in Colombia. It takes an administrative burden to watch out for as well. Something that was really interesting and gave, let's say, this regime teeth was the joint and several liability that the seller and the target company in relation to taxes, interest, and penalties. Also, the law says that the buyer could potentially be jointly and several liable for taxes, interest, and penalties as well, if it seems that the structure was based on or could be seen as abusive. So that I think that complicates things, but still it's a good let's say provision to make this regime actually work. And there are some few exceptions that are applicable for the regime. Technically, if the Colombian assets do not the amount of the Colombian assets do not exceed 20% of the total value of the assets of the company being transferred, technically the regime is not applicable. Here it's necessary to watch out for the commercial value and the book value. So it would have to check whether the threshold of the 20% is complied with in those both aspects. And also another exception is whether if the company is listed in the stock exchange. So that's something also to consider. And of course, the application of double tax treaties can also be an instrument to see whether this indirect transfer is applicable or not. Of course, there are many discussions about how double tax treaties are applicable with the indirect transfer regime. For example, just to give you two examples, the first one would be what article would apply. Is it the capital gains article, or it would be other income, or it would be Article 7 on business profit. So technically, it's been difficult placing the possible let's say income in those articles. However, everybody has its own opinion, and it's been fun discussing that with others. And the other thing is, depending on the type of transaction, the tax treaty may be applicable or not. So Juanpa, can you please, yes. So here we have an example, a typical example of an indirect transfer subject to tax in Colombia. So here's a Spanish company buying the shares of a Panamanian company from a Brazilian company. That Panama company has two assets in Colombia, one Colombian company and one immovable property, a house. So in this case, technically, it could be said that the entity subject to tax in Colombia would be Brazil. Colombia and Brazil do not have a double tax treaty. Well, maybe in the future, as I understand. And let's say this is not a sale, but a donation. So Brazil is going to donate the shares in the Panama company to the Spanish company. So the question is, in that case, the double tax treaty between Colombia and Spain applicable, considering that the entity subject to tax in this case is the Spanish company? And also there are questions whether, however, technically the company being transferred is Panama. So is it possible to apply the treaty? So there's some questions there. And the other thing that I wanted to point out is that you see there are two assets that are being indirectly transferred in that example. So technically you would have to assess the house separately from the Colombian shares, considering the rules that I already explained, because you have to watch out for the fair market value of the house and also the fair market value of the Colombian shares, as well as the tax basis. So that's been interesting to do so, considering this is just one sale, but there are different assets in Colombia. And the question is, do I have to file several tax returns for each asset, underlying asset, or just one, I would be compliant with local laws. So that's some of the stuff that we have been dealing with in practice, and it's been fun. It's a quite interesting regime, and I'm gonna pass it on to my colleague Gabriel to talk about the Brazilian regime, and then we're gonna go ahead with a comparison on both regimes.
Okay, thank you, Laura. First, I'd like to say thank you to IFA, ABDF, my dear friend here, Eduardo Muniz, who kindly invited me to speak about this very interesting topic. My dear partner here, Laura Duncan, and all the panelists. For me, it's a pleasure to be here. And yeah, about direct to the point, here in Brazil, our regime, we don't have a specific rule to deal with this indirect transfer of assets. We will see this later. And here the general regime is that you can see here in the screen. If you're a non-resident and you're selling an asset here in Brazil, you pay the capital gain tax, and the rate that will be applied will vary between 15% to 22.5%, depending on the gains that you receive from the transaction. So if your gains do not exceed 5 million reais, the rate that will be applied will be 15%. If your gains exceed 30 million reais, the rate that will be applied will be 22.5%. So you can see here that you provide in our law progressive rates to tax non-residents. It makes no sense at the beginning, but the reasoning for this provision is to equate the regime of the non-residents to the regime of the residents in the country. So the rates are the same. And here is important to mention also that if you're located in a tax haven, the rate that will be applied is the general rate for the taxation of when the non-residents located in a tax haven, which is 25%. In the other slide, you can see that before 2003, you didn't have in our law a specific provision for the taxation in the cases in which the seller and the acquirer of the asset are located in another country. So it came out in 2003 with this Article 26 that provided for this taxation in Brazil. So in this specific case, this is an exception actually to the general rule here in Brazil, in which to tax at the source you need to have the source of payment and the source of production here in Brazil. But what the Article 26 have done is to provide for this taxation even in this case in which the source of payment is not located here in the country. Different from Colombia, as I understood from the presentation from Laura, in Colombia, the seller has to register in Colombia and then collect the tax. Here in Brazil is different. Here in Brazil, the acquirer has to appoint an attorney-in-law, and this attorney-in-law has to collect the tax. There are some discussions if this law is right or not, because you have this rule, this general provision saying that the source of payment and the source of production have to be here in the country. But if you see to the Article 128 of the National Tax Code, you see that the law can appoint the responsible to collect the tax with the only requirement that this responsible he needs to have a link with the tax event, which in my opinion is the case here for Article 26. Contrary to Colombia, also, as I can understood from the presentation of Laura, the pricing here in Brazil may be stipulated by the parties without any legal restrictions. So even in case I don't see the application of the transfer pricing rules here, because you are not exporting any assets or rights in Brazil, and so there is no application of transfer pricing rules in this situation. So you can stipulate the price that you want, even if the seller and the acquirer they have same control. And one thing that's very controversial here in Brazil is the conversion actually of the cost of acquisition to reais. The taxpayers, of course, they say that this conversion has to be made on the date of the alienation, because in this way, you will not have any tax over this exchange variation, and the tax authorities have some positions in the sense that this cost has to be calculated according to the conversion in reais on the date of the acquisition of the asset. In the next slide. So going now to the topic here. As I mentioned, Brazil does not have a specific rule to deal with this situation. So Colombia has a rule. I know that Peru also has a rule providing that if you're selling a participation in a company located in a third country and 50% or more of this participation refers to a company in Peru or an asset in Peru, you have to pay capital gain tax in Peru. India also has a similar rule, but in Brazil don't have anything similar. What may happen here is that the tax authorities can disregard the operation. Here in the example, the operation in Panama, the tax authorities can disregard by saying that the only reason why you set out this company in Panama was to avoid the capital gain tax in Brazil. Here, it's important also to stress that here in Brazil, we don't have, the tax authorities cannot disregard an operation by saying that it was made with abuse of law or abuse of rights. So you can only disregard this operation if you consider this operation was simulated. This is important because in practice, you see a lot of tax assessments trying to tax these situations, but we don't have a specific rule providing that the tax authorities can disregard this operation by reason of abuse of law or abuse of rights. So the tax authorities in Brazil, they have to prove that this operation was simulated. And one very good evidence to prove that is in the cases in which this company located in a third country was set out for a very short period of time. So if you constitute the company in month 1 and after 3 or 4 months you wind up this company, this is an evidence. I'm not saying that you have to disregard, but this is an evidence that this operation was simulated. You have some case law in administrative courts here in Brazil. One very famous case is case COSAN, in which the tax authorities consider that the operation was simulated because the group constituted this company. In that case was Netherlands. They constitute the company in the Netherlands, and during the reorganization. So, in my opinion, maybe this is a good evidence to say that this was simulated, but I really want to stress the situation, because in Brazil, you only can disregard the operation if you consider this is simulated, and to do that, the tax authorities have to prove it was made with simulation. In the last slide, I think we can make some comparison here. I don't know if Laura wants to make some comments.
Sure. First of all, really interesting on the Brazilian regime. So what I understand is that technically only simulated operations are subject to the regime. Really complicated, I guess, for the tax authorities to try to prove that. So maybe, I don't know, and you can answer that, Gabriel, whether you have had many precedents or cases in which this was discussed or applied, because considering this is not applicable in a general manner as Colombia does or other Latin American countries do, it seems very difficult to apply the regime, right, in Brazil.
Yeah, exactly, Laura. Here, as I mentioned, the tax authorities have to prove. You don't have many case law dealing with these sort of situations. As I mentioned, we have one case, which is this COSAN case, in which the tax authorities disregarded the operation by saying that the company in the Netherlands was set out during the reorganization, and after 4 or 5 months, this company was liquidated. So this was a very good evidence to the authorities to say that, in fact, we didn't want to sell the shares of the company in Panama, but you desired to sell the shares of the company in Brazil. And that's why they said the operation was simulated. But as I mentioned, it's not a common It's not common to find in the administrative court this kind of situations, and the judicial courts, I don't know any case in which the judges had to deal with this very specific operation.
Correct. And other thing that I was very interested in hearing is, it seems that most Latin American countries, or at least South American countries, do have an indirect transfer regime. It seems Brazil has one, but it's very limited. So is considering Brazil to implement a similar system in the future as other countries do, or not?
I think we should do that, because if you have this specific rule to deal with this situation, you have much more secure. I don't know if you agree with that, but I think that the Colombia system is much more secure than our system.
Well, secure.
But you carry out your operation, and you know the results of this operation. Here in Brazil, we don't know. The tax authorities can say that that your operation was simulated even without any proof. You know, it's hard to have this kind of rule. I really prefer a specific anti-avoidance rule than the system that you have nowadays, in which you have a general anti-tax avoidance rule, and the tax authorities can do whatever they want. In my opinion, it's very complicated.
Another interesting fact was that that Gabriel and I discussed was the fact that in Colombia, very specific rules on pricing. Of course, it says always fair market value is the main rule, but it seems in Brazil it's kind of different. So it seems that the price is determined by the parties. So one of my questions to Gabriel was whether it could be agreed on, okay, we don't want to have any profits from any sales. So we could say that the tax basis is the same or equal to the price. So I don't know, I thought that was quite interesting, because it could potentially have an effect here, and it's very different from Colombia or what I've seen from other jurisdictions.
If you are doing a market transaction, probably you have a very good basis to tax this capital gain. But what's important here is that, in my view, there's no application of any transfer pricing rules here, because you are not exporting anything. And therefore, you can make this transaction. You don't need to comply with the market value. Again, even in these situations in which the seller and the acquirer have the same control. This is a situation in which they can stipulate the price that they want, and maybe without paying any tax here in Brazil, because as you mentioned before, the price that was stipulated can be below the cost of acquisition, you know.
Definitely. And one of my queries here or doubts was how to give teeth to these type of regimes. So it is clear in the case of Colombia that it included a rule on joint and several liability for the seller, and the target company, and the buyer. But in the case of Brazil, it's quite interesting, the rules that you have in place on that regard. So how is the tax office managing to actually enforce these rules and implement them?
Yeah, the tax authorities will go after the attorney-in-law, and yeah, he has to prove that the tax have been paid. It's a very hard situation. The tax assessment will be against this attorney-in-law, so you have to guarantee in your operation that the tax has been paid. So here in Brazil, the tax is paid by DARF. You know, this is the document in which you have to comply with your obligations. And what you have to recommend is that you be the attorney-in-law here in this case, but please ask for the DARF first before how can I say, before the tax authorities can assess your
Got it.
Your tax.
So I don't have any more questions or doubts. I don't know, Gabriel or any of the panelists. Do they have questions on this regard, on this topic?
Well, actually, I'm a bit stunned here by what Colombia is doing, because if I understood right, you're taxing someone in Colombia, for instance, as you put here, a Brazilian company that is selling shares of a Panama company which has assets in Colombia. So, so you have like Brazil, Spain, and they're doing the business, and I mean 3 levels below, or I mean 2 levels below, there's a Colombian asset. Yeah. And wow, that's quite intriguing, because I don't think is it some source of OECD guideline or something like that? Because it seems to me that probably you have the taxation on Brazil and Spain too in this transaction, right? So I believe I mean, you don't have actually a nexus, a clear nexus, yeah, I mean, involving the negotiation with Colombia, except the fact that you have an asset there, right?
Correct. So imagine, to making things worse, imagine that it's not just Brazil, Spain, and Panama, but also Latin American companies involved in the layers of the structure. And all of those already have indirect transfer regimes. So you have to, for a sale, you would have to check each legislation to see whether you're liable or not. So that complicates more. And just to answer your question, basically, from what I understand from a policy perspective, one, this regime was included to try to avoid those structures which is the same example that Gabriel was giving, the incorporation of companies abroad just to sell Colombian assets. And also because Colombia was running a little bit behind from other Latin American countries. They already have indirect transfer regimes. So that's something to watch out for when you are definitely going to sell a company that has many assets in other jurisdictions.
Yeah. Okay, I think if no one else has further questions on this topic, we can close the event. Just a final remark, I mean, if I could. I think I learned a lot. I really appreciate being here with you. I think from the first panel, Anna, and also from Natalia, we learned that perhaps it's very hard way to go to be admitted at the OECD, but maybe it's worth the costs and the effort. From the second panel, where joint panel from Bruna and Laura, I mean, congratulations, you could manage, I mean, to split the panel and make it so dynamic. Congratulations on that. And I think if we can learn something from that panel is that Colombia has really included in its tax law all the guidelines from OECD. Yeah, so it has like say the most sophisticated top of line rules regarding transfer pricing, but tax administration has a huge problem on applicating it because it's very hard, and sometimes you don't have the tools in order to do it. Whether Brazil has a very simplistic model, we can say, but it's, I mean, it has, of course, some we can make severe critics, yeah, to those margins, but once they are rebuttable, aren't we if we make simpler rules, couldn't we catch the same results, that is avoiding the profit shifting, which is the ultimate end of transfer pricing rules. And perhaps with the APAs and self harbors, we can make more certainty better, because here we can say that as from our perspective, and we have litigation all over our tax system, yeah, transfer pricing rules is not a matter of litigation at all. So maybe if we complicate it a lot, we can have big problems in the future. And from the last panel, I can say, I just said, I was really surprised by this indirect transfer legislation, because it's something we really don't have in Brazil, and I don't think our tax authorities are considering. But for you, just to give an example, we Brazilians, whenever we buy, I mean, anything using our credit cards in Switzerland, in Colombia, we are taxed by our tax authorities. They include tax, yeah, because we are, I mean, using credit, we are taxed on a rate of 6.38 of the value we're consuming because we are using a credit card. So we are buying things abroad and we are being taxed in Brazil. So I really hope that we don't have much more than that, because then it would be a huge problem. But I mean, just kidding on that. But I mean, everything it's very interesting, and I can thank you, all of you that participating, and especially Claudia. I mean, you're awake and you're here with us all the time. And I mean, if you want, we can testify that you stayed until 2 o'clock in a tax event, right?
Exactly.
I mean,
no, it was actually better than watching Netflix. So I think congratulations on this great panel. I really admit that.
No, I'm just kidding. I mean, if you wanna give us the opportunity, we can start early. You can invite us for an event in 7 morning in Switzerland. You know, Eduardo Muniz, he's a marathonist, and he wakes up very early. So instead of running, he can be watching, and he will be, of course, very, very pleased to attend an event. Okay. No, just kidding.
I mean, bear that in mind, definitely.
No, it was very nice having you here. So guys, many thanks. I think we did an excellent job here. And as I said in the beginning, it's the first of many. And it's very good that, unlike in soccer, here on Tax Matters, we are all running and playing on the same team. So a big pleasure. And I think, Juan, if you could say the final words, please.
Yes, of course. Thank you, João. Thank you, Laura and Gabriel. It was really amazing presentation. I really enjoy the way you compare the two systems, which I think they can simplify one of the main conclusions of this whole panel, of this whole event, where we can see that in some cases, Brazil has like a more simple regulation in some things, like in this indirect transfer regimes, and Colombia maybe is too complicated. So and this two like so extreme points, so different points, maybe make things for us a little bit difficult. Maybe I think we should get to a middle point where the regulations aren't that strict, or maybe that's that simple. I think this is something I would say as a whole conclusion of our event. I also want to say that I really want to thank the speakers and all the people that made this possible, for the time and their will to support these academic initiatives. Personally, I think the three panels were absolutely interesting and full of information that will be very useful for our professional practice. And as I said before, I hope we can continue with these events in the close future, and hopefully with other countries from the South American region. And for all the audience, thank you for your attendance, and please don't forget to keep joining YIN IFA events, as well as following us on the different social media accounts. And well, that was everything for today. Thank you very, very much, and I will see you soon in a second Colombian Brazilian event. Thank you very much.
Thank you all. Bye bye.
Thank you. Bye.
Thank you.